that we are looking to discuss, explore is entitled Affirmative Action Pride. And we're calling it an abstract, but it really is a set of questions, in the sense that an abstract would give us typically what the hypothesis is, what a provisional conclusion is. And because of the relatively underexplored character of this topic, we could make a productive start by posing a set of questions. And we may or may not be able to get to any conclusive set of answers at all. But this is to know that there is a value in posing questions. And part of the project, part of any curiosity, part of any kind of research inquiry is indeed the starting with the set of questions. I'm trying to see if I can switch on my camera, and something has happened between sharing of screen with this slide and now that I've lost control of the platform on which this session is streaming. So I'm going to stop sharing the screen, and let's see if we can switch on the camera, which should happen now. Can anybody say? Can we do an audio and a visual test? I suppose I'm audible because I might just be speaking to myself. Somebody say if I'm audible in the chat window. Yes, okay. Am I visible? Somebody say if I'm visible in the chat window. So this is a yes. Yes, you are visible. Okay, good. Okay, now let's see if we can share. So all of this is good because what we are doing is setting up. Otherwise, we would be doing this even if we were to start at 3:40, we would be doing the several rounds of am I audible, am I visible. So we are using this time to get all of that out of the way. And we could do a little more. We could do with a little more. What can I say? Participation from our attendees, and certainly at some points, unless we want this to be a monologue, what we would welcome is for our attendees to unmute themselves and to stop, to interrupt, and to pose questions, comments, because this is an exploratory idea. And the thing about exploratory ideas is that there is relatively lesser amount of insights available to us. So then what we do is pose questions. So even if we don't answer all of those questions, we've begun our journey of inquiry by posing these questions. So before we get to that, we are starting with a premise. And the premise is this, that recipients of affirmative action, such as reservations in education and in employment, are often subjected to stigma and discrimination. Some of us may agree, some of us may disagree, and yet that is a premise that we are starting. It might be a hypothesis, if we were doing this in a more, as a research method, we could pose this as a question. Do recipients of affirmative action, such as reservations in education and in employment, are they subjected to stigma and discrimination? And some of us might get to an answer that yes, there is stigma and discrimination. Some may say, what are you talking about? There is absolutely no stigma and discrimination. There is only gain and yay, more power to affirmative action. Okay, so that's the premise we are starting on. And then a question. It is 3:40 now. So if the organizing team want to, tell me to stop at any point, please do that so that we can. This is a kind of a preview we can stop this preview and revert back to the organizing team and allow for our organizing team to start with, the formalities of introductions, as well as a little bit of idea about what the webinar is, and understand it's a series of webinars. Yeah, so if that's what we want to do, so I'm going to be looking for some kind of a clue from our organizers, which is going to tell me that, all right, the preview is enough. Now we are ready to start. Counting 1, counting 2, counting 3.
Hello,
And
hello, sir. Can you hear
yes,
me, sir?
yes.
So I like to introduce you, and I like to apologize as because of technical issues. Saptoshi isn't there. He will be here very soon, and we can start off with this lecture. And I like to introduce you, Professor Sumit Baudh, sir. Will be talking. Uh, so Sumitra Chand, sorry, and he'll be giving and giving us a lecture. Please, sir, I request you to start with.
I'm visible and I'm audible. And if I'm not, I'll be looking to the chat window to tell me otherwise.
Yes, sir, you are
Very
visible.
good afternoon and welcome to this excellent initiative taken by the All India Queer Association, the study circle of All India Queer Association. And I'm very thankful and very grateful to our friends in the, if we are using the acronym, then, if I don't know phonetically if we say ICA, All India Queer Association Study Circle. So I'm very grateful to them for thinking of me and for including me in this important series of webinars. I'm both humbled and proud to be associated with many of our scholars, many of our academics who are engaged in the area of sexuality studies. We know that sexuality studies is something which has known some degree of the opposite of advancement. That means that there has been a gap in existing more conventional forms of scholarship, and those gaps have necessitated for the need for sexuality as a discipline, sexuality as an area of study. So, relatively speaking, it's a new area, and which is why it's that much more valuable, the amount of interest that we have within the academia, especially within students. So I'm presuming that ICA is mostly student led, and I think that there is a value to student mobilizing because of the openness that there is to posing questions, to finding a provisional set of answers and conclusions, something that perhaps more of us who get more and more established into our ways of thinking are unable to do. Also, there is a special place and value to student mobilizing because of the earnestness of effort with which it comes. So, with that, I'm just really, really humbled and proud to be associated with the study circle of the All India Queer Association. Today, we will be talking about affirmative action pride. And with this now, we're going to be sharing screen. I'm going to be sharing screen from my end and using a set of PowerPoint slides. Hopefully, this will provide us visual clues of, often when we are on a digital media, when we are on a virtual platform, because of technological problems or technological constraints at our end, sometimes the audio may not be that good, sometimes the video may not be that good. So we try to marshal as many resources, as many ways of communicating that we can, so that any amount of those constraints can then be balanced. So we're calling this affirmative action pride, and we are calling it abstract, although it's more of a set of questions. And a premise that we are beginning with is that recipients of affirmative action, such as reservations in education and in employment, are often subjected to stigma and discrimination. This premise we are supplementing with a set of questions. For example, again, sorry, before we get to questions, the premise would continue that this disables us from being open about our location within reserved categories, and it forces us into the proverbial closet. As we invoke the idea of proverbial closet, what we are doing is we are starting to borrow from a set of vocabulary and conceptual frameworks that have originated within our understanding of what we know broadly as LGBT queer studies, lesbian, gay, bisexual, transgender queer studies. So the proverbial closet is that which individuals might be compelled into, individuals might choose to be in, but in some way, individuals are able to keep certain aspects of themselves private in such a way that any intrusion or invasion of their privacy would not be detrimental to them. So, if that is the proverbial closet, then there are many dimensions of human lives that might be so private, that might be so vulnerable, that might render us vulnerable. And for us to undo that element of vulnerability, we might be keeping from disclosing those dimensions of and about ourselves. Yes? Did somebody unmute themselves? Did anybody want to say something? Okay, so continuing this idea of proverbial closet. So it is partly safe, and yet it is stifling, traumatic, and isolating. The safety part, of course, is that if any disclosure of information about us is going to make us vulnerable to what? Vulnerable to stigma, shame, discrimination, then perhaps we are better off not disclosing that dimension to anyone. But the thing about non disclosure is that there might be several pockets of that non disclosure resulting in isolation. And that isolation could foster a sense of shame, a sense of trauma. And so, as much as the closet might be safe, somebody is requesting to annotate. I don't know how that works. I'm very happy to receive this kind of an input from our attendees. And I hear an echo of my voice. So now I don't. Okay. So then here are the set of questions that we are considering. Now, okay, so something has happened and I'm unable to move my slides now. And the cursor shows me a little pencil. So whoever I shared this with, please do something and unshare this, because all of this was going quite well until this slide was shared with somebody. Pooja Patra 0804, can meeting recording is in progress. All right, guys, I'm stuck. I can't move these slides. Somebody help me. Somebody, anybody? Okay, I'm just going to stop sharing the slide and share it again. All right, so this is moving now. Hopefully, all of this is reaching your ends, and we are at the slide in which we've begun with our first question. just in case there is any communication gap in on this platform, I am connected with some of our organizing team with Shaptashi over WhatsApp. But if Shaptashi is not present within the team right now, then please check your email account, and I have my phone number there. And if at all there is any gap, then I could be sent messages over WhatsApp so that I know that all of this communication, audiovisual communication, is something that is reaching to our attendees. So, with the premise of there being stigma and discrimination associated with affirmative action, and with the borrowing of a conceptual framework of the proverbial closet, we want to ask, what would it take to undo this isolation and to be out and proud of our location within affirmative action categories? And look, yet again in this question, what we are doing is that we are borrowing certain conceptual ideas, discursive ideas that have emerged in a discursive understanding of the lesbian, gay, bisexual, transgender, and queer experiences. So, what would it take to undo this isolation and to be out and proud of our location within affirmative action categories? Could the reserved constituencies, such as the scheduled caste, the scheduled tribes, and backward classes, find any solidarity within and inspiration from the lesbian, gay, bisexual, transgender, queer pride mobilizing and consciousness? Are there any equivalents of slogans like gay is good and black is beautiful within Dalit, Adivasi, and Bahujan self-identifications and assertions? Could a wider formulation of pride be an undoing of the multiple forms of invisibilities, erasures, and silences? Are there any affirming ideas and experiences of affirmative action? What does it affirm? Is affirming something, if affirming something is to offer emotional support, does affirmative action do this? And or also the opposite, which is what? That is to evoke intense emotions of anxiety, resentment, and ill will. If stigma is a necessary condition or cost of affirmative action, then could there be affirmative actions against affirmative actions to mitigate the conditions and costs of stigma? And lastly, are there any other questions that we need to be asking? Again, to repeat, this is an exploratory idea. I'm not presenting myself as the know-all. Hopefully, this webinar is going to be a discussion in which we could be considering some of these questions. We might start with a broader question, which is why even pose this question? What is it about affirmative action that might have any relevance to the ongoing contemporary LGBT queer discourse? Or is this something which is contrived? Contrived in the sense that, somehow we are trying to force one idea into another. And we are trying to, uh, borrow from the conceptual frameworks that are applicable to LGBT queer discourse. So maybe partly appropriating, and we know that there is a profound significance of appropriation, because it takes movements, it takes people, years and years of agony, interrogation, collectivizing to get to certain ideas. And then for someone else to just borrow those ideas or to appropriate them could be something that could be troubling and at least needs to be flagged as such. So then, why is it that this question even becomes important? This exploration of affirmative action pride, this exploration of the commonality of the closet, commonality of the closet in the sense that various ways and means in which we keep dimensions, we keep aspects of ourselves secret, and we are unable to disclose them for the fear of prejudice, for the fear of stigma, shame, discrimination. So we're going to be looking at least one site in which there is an overlap. There is an overlap in the sense that affirmative action, we know, is something that begins to be explored with the National Legal Services Authority versus Union of India, a case of 2014 in which the Supreme Court of India provided the legal recognition of transgender persons as third gender. And part of the outcome of this case was also the prescription that there ought to be some kind of affirmative action, that there ought to be some kind of reservations. So let us start with that overlap, because then many of these questions that we are posing seemingly in the abstract and seemingly disconnected to why this question is important, then it becomes important within the location of an intersection, not just an abstract intersection, but an intersection that has already occurred. It has occurred within the site of legal advocacy, within the site of law reform. And we know at least part of socio-political mobilizing of the lesbian, gay, bisexual, transgender, queer movements is keeping sight of law reform. And there are various sites of reform, and law is one of them, and it's not the end all. But certainly it's an important avenue in which much of this mobilizing channels many of its efforts. And as we do that, it's important for us to know how we conceive of certain ideas, how we conceptualize them. In what way do we prepare our arguments? And what do we ask the court? And what is it that the court gives to us? So one question for us could be, in this case of, and we're going to be shortening this, National Legal Service Authority versus Union of India, we're going to be using NLSA, and therefore phonetically we're going to be calling it the NALSA decision. So in the NALSA decision, we know that there is the outcome is partly, which is the prescription of affirmative action. We want to know who is it that who asked for this affirmative action? Was it something that was a making of the court of its own by itself, a recognition of the terrible condition in which the third gender is currently undergoing, and therefore some kind of affirmative action is only in order. So who is it who asks for this affirmative action? What are the terms on which it is being asked for, and what are the terms on which it is provided? And before we get into some of these, I just want to say that the method that I will be following for this webinar is that I'll be borrowing from a paper that is entitled Demarginalizing the Intersection of Caste, Class, and Sex in the Legal Conceptualization of Transgender Persons and Sexual Harassment of Women. This is from a manuscript as of the 11th of May of this year. It's a work in progress, and it is something which is a forthcoming publication in the Journal of Human Rights. And this is a version which is currently under some amount of review and revision based on the reviews that we have received from the editorial team. So I'm going to be reading from this paper, excerpts from this paper. I won't be reading all of the paper, but I'll be reading excerpts from this paper. So that's the method that we are following. So, so what is it? What does it mean to demarginalize something? To demarginalize something is to displace it from the margins and to bring it to the center. The National Legal Services Authority versus Union of India, NALSA, deploys a combined bulwark of human rights and fundamental rights, and it is widely considered to be progressive legal advancement. It is an outcome of a public interest litigation, in short PIL, which is a constitutional law remedy that allows certain procedural departures from formal legal requirements of what we know as locus standi, which is cause of action. That means petitioners of PIL are not required to prove any personal injury or grievances to themselves. NALSA is then a precursor to the Transgender Persons Protection of Rights Act 2019, which could be referred in short as the Transgender Act. This legal conceptualization of sex based equality is insufficiently informed by the underpinnings of caste and class that are marginalized or erased in NALSA. This presentation today will attempt to recover some of the lost intersectional potentials of NALSA and to inform us of the ongoing and perhaps future law reform endeavors of the possibility of more transformative justice. This presentation also aims to explore ideas towards forging intersectional solidarity amidst the Dalit and the LGBT queer mobilizing combined. Categories of backward classes, the scheduled tribes and the scheduled castes, have contextual meanings within the Constitution of India. The scheduled castes and the scheduled tribes are constitutionally protected categories that are listed in more detail in their respective presidential orders of 1950 each. The idea of backward classes is also conceived within the Constitution. Literal meanings of the word backwardness could have pejorative connotations. To a racialized colonial mindset, perhaps all native persons were backward and uncivilized. The Hindi word pichde could be translated differently as those who are left behind. A related term, such as forward caste and classes, are discursive outcomes of the legal formulations of backwardness. By default, then, forward caste would be all caste denominations that are not categorized as backward classes nor as the SC or the ST. Castes are historic and social gradations of hierarchies, stature, power, privilege, advantages, disadvantages, work, occupations, and other caste based prescriptions that are assigned at birth and secured by endogamous marriages. Some meanings and deliveries of these hierarchies might have shifted over time, yet the salience of caste to systemic inequalities has endured. The Constitution of India recognizes these pervasive inequalities and provides remedial affirmative action measures that are known as reservations. There are reservations for the SC, the ST, and the backward classes in public and private education, public employment, electoral constituencies at the local, state, and federal levels. There are also extensive frameworks of special legislations that seek to prevent and remedy caste based violence and discrimination, such as the Scheduled Caste and the Scheduled Tribes Prevention of Atrocities Act 1989, in short, as the SC and the ST Act. Despite this bulwark of constitutional and legislative measures, caste is alive and kicking. And despite a pervasive salience of caste, there are denials of caste based inequalities and a kind of caste blindness, which is what? An inability or reluctance to discern caste, even within some of the more progressive law reform initiatives. Caste blindness or more brash denials of caste have resulted in certain erasures, silences, and invisibilities. And partly this undermines any research that then tries to trace the invisibilities and erasures. We could start first with a comparative applicability of intersectionality, because something that we are about to discuss would rely on some kind of conceptual frameworks, theoretical frameworks, and a theoretical conceptual frameworks that we will be relying on is that of intersectionality. The conceptual framework of intersectionality began by drawing attention to Black women's experience in the face of anti-discrimination law, and in feminist theory and anti-racist politics. In the foundational work by and of Black feminist scholar, academic, Professor Kimberly Crenshaw in 1989, and that work is entitled "Demarginalizing the Intersection of Race and Sex in Anti-Discrimination Doctrine," and goes on to include other aspects as well. But the reason why we are flagging that here is that this work in progress article that we are borrowing from, that we are reading excerpts from, is inspired by that foundational piece of Professor Kimberly Crenshaw, and is therefore titled similarly as on the lines of demarginalized. So, Crenshaw, 1989, explained legal conceptions of anti discrimination that view subordination as a disadvantage along a single axis, one of the two, race or sex. This single axis failed to remedy discrimination experienced by Black women because of a legal understanding that places Black women's experience as too similar or too different from the experiences of white women and Black men. Intersectionality originator Kimberly Crenshaw suggested that Black women experience discrimination in ways that are similar to and different from white women. Yes? Say something? Or was that an accidental unmuting? And at any point, if this is anybody wants to stop and want me to stop and clarify, I'd be happy to do that. So that would make it more interactive, because beyond a point, even just reading of this excerpt is going to be relatively uninteresting for me as well. So if at any point there are any of our attendees who want to pose a comment or a question, we are entirely open to that format, and we're not just open, we welcome it. Okay, so then we are at the single axis framework of anti-discrimination law is explained through a metaphor of traffic intersection, where motor vehicles represent different axes of discrimination. At this metaphorical traffic intersection, a Black woman injured by two or more motor vehicles is denied remedial treatment only because any one motor vehicle cannot be identified. The genesis of intersectionality does not accord any conceptual or foundational significance to this metaphor. Similarly, while Black women are a subject of intersectionality at its origin, there is nothing in the conceptual framework that limits the application of this framework to Black women only. Indeed, a growing understanding of intersectionality has shed light on many other issues. For example, discrimination experienced by Muslim women, Black gay men, HIV positive, transgender persons. Now, unrelated yet somewhat similar to the genesis of intersectionality in Crenshaw 1989, a book project by the name of Tools of Justice, authored by Kalpana Kanaberan and published by Routledge in 2012, presents an understanding of intersectional jurisprudence in India. This book project presents a critical engagement with the law in the context of routine perpetration of atrocities on entire communities. Many structural linkages between subordination and discrimination. The book project shows how denial of liberty inaugurates discrimination. Discrimination is thus secured by a routine and systematic violation of liberty. A central argument in the book is that we can only begin to understand non-discrimination in Article 15 of the Constitution if we draw a jurisprudential nexus with the right to liberty in Article 21. So there is the proposition that we need to read Article 15 and Article 21 in an interconnected manner and not in isolated manner. Now, although Kanabiran does not make any references to the conceptual framework of intersectionality, the central argument is aligned with the broader structure of Crenshaw 1989. How it starts with an analysis of the anti-discrimination framework and proceeds to Black liberation politics in the US. This discursive turn from anti-discrimination to liberty is echoed in the central argument of Kanabiran 2012 that goes on to present certain interpretive strategies as illustrations of the intersectional jurisprudence. For example, the judicial recognition of hostile environments that entrench discrimination through curtailment of liberty. And that might sound familiar to those of us who are familiar in our reading of the famous Vishaka guidelines. Kanabiran 2012 explores this central argument. What is the central argument? An interconnected reading of non-discrimination in Article 15 and liberty in Article 21. The book explores this central argument with reference to 6 distinct groups, which are persons with disabilities, Dalits, Adivasis, religious minorities, women, and sexual minorities, in that order. Therefore, the book does not consider any significance of intersectionally subordinate groups such as scheduled caste women and scheduled caste transgender persons. A dialectical discourse between Nivedita Menon and Mary E. Jones on the usefulness of intersectionality is also instructive. The dialectic is based on a mistaken understanding that intersectionality is a conceptual framework to explain identity formation. I'm open to comments, questions. So I heard somebody unmuted themselves. Don't be shy. Okay, counting 1, counting 2, counting 3, and moving on. Okay, a dialectical discourse between Nivedita Menon and Mary E. Jones on the usefulness of intersectionality is also instructive. This dialectic is based on a mistaken understanding that intersectionality is a conceptual framework to explain identity formation. While John engages with Menon in many useful ways, that essay does not clarify this foundational misunderstanding. What is the foundational misunderstanding? That intersectionality is a conceptual framework to explain identity formation. That is a mistaken understanding because intersectionality as a framework makes no such claims, not at least within the legal discipline in which intersectionality is said to have its genesis. Of course, intersectionality is going to be interpreted differently within a range of disciplines. And that is not to say that, that we have to be fundamentalist and must stick to the point of genesis. But this is just to say that the site of origin or the site of genesis within a disciplinary understanding in the law, intersectionality is not making any such claims. Intersectionality within disciplinary understanding of law does not make any such claims that now there is going to be a moment of revelation and explanation of identity formation as such. Although partly what intersectionality does do is look to the existing identity formation within the law. What are the categories? What are the classifications that the law creates? That is something that intersectionality is interested in exploring. So, amidst other arguments, and while referring to the metaphor of the traffic intersection, Nivedita Menon, in her article in EPW in 2015, states, and I quote, rather than a Black woman being both Black and a woman, she may at times be only Black and at other only woman. The intersection itself is an empty place, unquote. And here we want to say, indeed, yes, the intersection is an empty space. This is not a point of critique of the conceptual framework of intersectionality, because even in the metaphor, it is animated by motor vehicles that are metaphors for multiple axes of discrimination. These motor vehicles simultaneously collide with a Black woman in a way that it is not clearly discernible as to which vehicle caused the injury. And when the ambulance arrives, what happens? Again, the ambulance, arrival of the ambulance is a metaphor for remedial function of anti-discrimination law. And this ambulance inquires about the precise cause of injury, that is, which vehicle exactly caused the accident. And this could be, for the purposes of settling any insurance claims or whatever. We don't know why exactly the ambulance needs to know in such precision as to what the cause of the injury is. We know that the ambulance requires this bit of information. And given that a clear cause of injury cannot be so identified because of the simultaneous collision, the ambulance does not attend to the Black woman, and both the vehicles and the respective drivers get away scot free. As such, the intersection is an empty space, yes, and intersectionality is not a conceptual framework to explain identity formation. Several other scholarship works, such as Professor Cho, have placed an emphasis on intersectionality praxis. So, one part is the conceptual frameworks and the theory, and one part is practice. The intersectionality praxis that could show the working of this conceptual framework. Despite its invocation of untouchability that is implicitly and predominantly caste-based, the judicial outcome of NALSA is steered into a single axis frame of gender. So here is what we are doing now. We are making a transition from a theoretical conceptual understanding of intersectionality. We are making a transition to a site of praxis, the site of praxis being that of NALSA. So despite its invocation of untouchability that is implicitly and predominantly caste-based, the judicial outcome of NALSA is steered into a single axis frame of gender. These are sites of law and practice in India that illustrate more effectively the application of the conceptual framework of intersectionality. Menon 2015 has rightly said, and I quote, "Theory must be located, and we must be alert to the spatial and temporal coordinates that suffuse all theorizing," unquote. And we could attempt to do some of that locating within the text of judicial decision of NALSA. So that's where we transition from a conceptual theoretical understanding of intersectionality to the praxis of NALSA. And this part that we are reading from is entitled Transgender Like Untouchables. And here is a premise that we start with, that the rhetorical claims, such as transgender persons are like untouchables, imply that discriminated groups are somehow placed in mutually exclusive set of people. These claims imply that the emerging understanding of one is just like the previously existing understanding of another. So, for example, in the US, rhetorical slogans like gay is the new black is an example of this kind of rhetorical claim that sets apart gay persons from black persons, such that all gay persons are posited as white. Not only is that empirically incorrect, it appropriates and distorts a discursive understanding of one social movement onto another. These distortions are amplified within legal movements in which the previously known discriminated groups are disabled from representing the newly emerging group. Rhetorical propositions such as transgender persons are like untouchables generate blind spots that invisibilize untouchable transgender persons and disable their representational agency. Consider this excerpt from the opening paragraph of NALSA. I hope that in addition to the audio, many of us are also following the text that would appear in our PowerPoint presentation slides. And there we have an excerpt from the opening paragraph of the Supreme Court decision in NALSA. And this is the second sentence in the decision. And this is not just the one time. In the text of NALSA, on a recurring basis, there is a mention of the similarity or this comparison between the so-called untouchables and the transgender persons or the transgender community. So the select quote that we are looking at is our society, quote, our society often ridicules and abuses the transgender community. And in public places like railway stations, bus stands, schools, workplaces, malls, theaters, hospitals, they are sidelined and treated as untouchables. And unquote. So this analogy with untouchables appears in several other parts of the court decision, although only in the passing and in the margins, without explaining why this analogy is being made in the first place. Is it for an eventual recognition and declaration of transgender persons as a backward class? Who decides this legal status of backwardness and how? And to what effect? Is untouchability the same as backwardness? Does backwardness require parity of status with untouchable scheduled caste? To be able to respond to these questions, there has to be a demarginalizing of this passing analogy. Consider this supplementary narrative to enhance the intersectional insights, reach, and consciousness of NALSA. The transgender community is not just treated as untouchable. Some of them are untouchable. If the Supreme Court had considered a reality of untouchable transgender persons, it might have seen an overlapping function of caste, gender, and sex categories. With that, the court might have considered some of the similarities and differences between the emerging legal understanding of third gender and scheduled caste categories. The two could be said to be similar because both gender and caste categories are assigned at birth. They are different because gender categories can be legally changed, while caste cannot be changed. Sometimes the law imputes a loss of caste, yes. That does not imply change of caste status from one to another. This characteristic of immutability this characteristic of immutability of categories has a significance in the doctrinal understanding of anti-discrimination law. That is to say, categories are so immutable that the recipient of discrimination cannot choose to opt out of the categories that are so assigned. Now, in the absence of any kind of an interaction from our attendees, what we could do is, maybe refer to one of the sessions as part of this webinar series, which was led by Dr. Rahul Sen, which was roughly titled Queer Way of Thinking. Now, in that, what we had was a discussion of anti-discrimination as one of the sites of queer interventions. Now, the contradiction in selecting anti-discrimination as a site of queer intervention, especially that which is going to begin with critiquing identities or a fixation of identities, as it's going to argue for a non-identitarian perspective, then it's going to be something that is contradictory, because partly pursuit of non-discrimination is going to require some fixation of identities, not just fixation of identities, also certain immutability of categories. Because if there is the flexibility of categories, there could be a premise that would disallow the application or the applicability of anti-discrimination, because if these categories can be so freely chosen, then why would anybody choose to be in a location of discrimination, stigma, prejudice, and shame? So this characteristic of immutability of categories has a significance in doctrinal understanding of anti-discrimination law. That is to say, categories are so immutable that the recipients of discrimination cannot choose to opt out of the categories that are so assigned. What about these similarities and differences? What do they yield? How are they productive? Most importantly, what is the lost intersectional potential of NALSA? Foremost, in its omission of caste, NALSA loses an opportunity to learn from the existing legal discourse discourse on caste, class, and affirmative action. And we put out this select excerpt onto our PowerPoint presentation slide because we do want to highlight some text so that we are able to follow the main highlights or the main points of what we are trying to present in this talk. So, in its omission of caste, NALSA loses an opportunity to learn from the existing legal discourse on caste, class, and affirmative action. Amidst other post colonial continuities, the legal idea of backwardness finds explicit, yet undefined, mention in Article 16.4 that allows the state to make provisions for reservations in public employment in favor of backward classes. The category of socially and educationally backward class was inserted in Article 15.4 as part of the First Amendment in 1951. That was partly to overrule a contrary outcome of the Supreme Court in the decision of State of Madras versus Champakam Dorairaj. Thus, there have been intense contestations over caste and class based affirmative action since the very inception of the Constitution. The conflation of caste and class is also common. A government memo of 1990 sought to provide 27% reservation for other backward classes, in short, OBC, citizens in central government employment. And this is the famous Mandal Commission, implementation of the Mandal Commission. This was in addition to the existing reservations for scheduled caste and scheduled tribe citizens. These existing percentages of reservations were already opposed by a segment of citizens in the non reserved general categories, as in the higher echelons of caste based hierarchies. Reservations for OBC categories stoked this opposition into a widespread public protests. Most evocative of these protests were perhaps delivered in a series of self immolation by some of the general category students. The intensity of anti reservations rhetoric escalated several notches. In a more commonplace understanding and delivery of this rhetoric, the SC and the ST persons were positioned on the front line or the face of reservations. There was a conflation of newly proposed reservations for the OBC persons with the already existing reservations for the SC and the ST persons. And it was the latter who bore the brunt of public stigma and discrimination. Formal legal writ petitions were filed in the Supreme Court to stall this implementation of OBC reservations. An unusually large bench of 9 judges was formed in Indrasani versus Union of India to consider the constitutional validity of the government action. Amidst longer list of issues, Indrasani sought to determine the meaning of backward classes of citizens in Article 16.4. Pointing to the primacy of caste in determining inequality in India, the Supreme Court sought to determine how the words caste and class were understood at a time before the Constitution came into being. In pre independence India, the expressions class and caste were used interchangeably, and that caste was understood as an enclosed group. The earliest known English legal formulation of the category that would come to be known as scheduled caste was depressed classes. The Supreme Court clarified that the meaning of class in Article 16.4 was not derived from the understanding of Karl Marx, the philosopher, economist, and sociologist. The word class in 16.4, and here we are quoting from Indrasani. So we quote the word class in Article 16.4, in our opinion, is used in the sense of social class and not in the sense as it is understood in Marxist jargon, unquote. In its effort to determine the meaning of backward classes, the Supreme Court made this rough correlation of class and caste. While this was useful for justifying the use of caste categories to determine backward classes, it ended up undermining the gravity of both caste and class. The crux of comparative political discourse on caste and class is in the failure of the Marxist left in India to recognize the salience of caste and a corresponding failure of the law to recognize the salience of class-based inequalities in the Marxist sense. Legal discourse on backward classes is then based on a sterile.
Excuse me, sir.
Yes.
Could you just explain the Marxist way of class for me? Which you were talking about, like the classes, class and caste.
I would be. That's going to be a longer discussion. Was there any? Why is it that this question is important? Is it that we don't have an idea of the Marxist understanding of class, or is there something else that is prompting this question?
No, that understanding. I don't have that understanding right now.
Okay, so I think that it would serve us better to develop that understanding elsewhere, because to attempt to develop an understanding of Marxist understanding of class, it would be to not be able to do that at all. So part of what we are presuming is that we have some understanding of the Marxist understanding of class, and we are getting to a critique. But then it would be, we would not be able to gain any understanding, a critical understanding, if we don't have the foundational understanding of Marxism and class in Marxism. And I think some of those ideas are better explored within classroom settings and within curricular materials, which are going to be introductory. And I understand that many of us are going to be placed within disciplinary fields that may not allow us that kind of reading. So I don't know. I'm going out on a leg here because I don't know.
Yeah, actually, is it like working class and labor class, that thing, or something else? What are you talking? Because we are talking about the class of like in social. Yeah, social sense, the classes and all are based on the caste system, and class system is different, I guess. And the Marxist one is, I guess, I don't remember it exactly because I've been not even touching that. But is it like working class and the upper class thing, which the employee class and all? Is it something like that?
Can you tell me a little bit about the disciplinary understanding that you're coming from? So that would help me know who I'm speaking to. What might be some of the disciplinary understanding that you might be working with. So are you enrolled in an undergraduate course or a postgraduate course or in school?
No. Actually, I'm a postgraduate only, but my field is biological anthropology. I had a social anthropology in the thing, but I don't remember it exactly right now. That's why I was asking you exact definition.
What was your undergraduate degree?
So it was anthropology.
Anthropology would introduce and discuss Marxism and ideas of class. So very quickly, the proletariat, the bourgeois, and the very idea of class conflict. That history is a class conflict. Some of the other ideas which are salient features of Marxist understanding is that law is a tool of oppression. It's a tool of oppression.
Okay. Now
so
I got it.
the class struggle, the proletariat, the bourgeois, that class struggle then becomes the very basis of the history. And law is characterized as a tool of the oppressor. Whereas now we bring it to a legal understanding. So the reason why a legal understanding is devoid of this Marxist understanding of class struggle is because the legal understanding of class is class as in classification. There is a doctrine of classification that only looks at what is the category, what is the classification. And that legal understanding of classification would study with the kind of equal attention the classification of, say, movable assets and immovable assets. Or it would study with equal attention the classification of animals such as mammals. It would not lend unless we study how we understand substantive inequality. Formal equality mostly studies class as a classification, that here is a category of people. But if we are to locate class in Constitution of India, and this is a this is a site of this is a historical site of contestation within constitutional law, because at the making of the Constitution, we know that the socialists and the communists had boycotted the the making of the Constitution, as in the Constituent Assembly, and there were ideological differences, very very bitter differences, and those differences continued to play out in the implementation of the Constitution, where some of the earlier sites of contestation were precisely brought on ideological grounds. So then it becomes very important to trace that class, that understanding of class, because of the ideological disassociation that happened at the time of the making of the Constitution, and because of the ways in which ideological, some of the responses that there are, for example, to the subject matter of law reform, could be discarded, or could be treated with relative, some degree of lesser importance, because after all, what is law and what is the significance of the law, if not only in the paper? So if it is something only in the paper, and if it is the tool of the oppressor, then why even engage with the law reform process? And these are some very, very real areas of praxis in which, within movement spaces, we are going to find articulations as that. As in, when we are talking about law reform, then there is some of us who disassociate ourselves from any attempts or any initiatives for law reform, because largely they are seen to be the tool of the oppressor, and therefore any outcome of that would only advance that. So those are some of the ideological positions, critical ideological positions, that we could be looking to contest. We could be looking to engage. I mean, we can decide to whether we are going to contest them or we're going to agree with them, but we could at least highlight them as ideas that then become points of discussion and contestation. So the legal discourse on backward classes is then based on a sterile and simplistic meaning of class that could be. Yes?
I had to flag something. Can you hear me?
I can, yes.
Yes, so I was actually having some threads in mind when we were talking about the NALSA judgment, which is with respect to how the transgender identity in South Asia focuses around the centrality of the Hijra figure. And while we are talking about the Hijra identity in itself, it is not a monolithic framework. It is like a constellation of marginalizations that is contained within that very identity. So while NALSA also mentions Hijra, it is interesting to look at how it conveniently does not take into account caste and class questions that are almost inherent within that particular identitarian framework. And also in the context of how the Transgender Act, it tries to it tries to criminalize some forms of traditional Hijra livelihoods, such as begging and khajra. So how do you connect these threads and look at transformative justice from there?
And so I want to know, who am I speaking to?
Okay, my name is Orithro. I identify as a trans feminine person, and I'm an MPhil trainee in clinical psychology.
Okay, okay. Thank you for that question, Aritra. There's an echo. Okay. If you could, yes, okay. Certainly part of our reading of NALSA is that NALSA has not attended to questions of caste and class. And the question is, are we going to leave it at that critique that NALSA has not attended. So what? So what NALSA has not attended? Another way of asking this question could be, what would be the outcome of NALSA, or what would be those insights that would illuminate the subject, that would inform the Honorable Supreme Court if it was to attend to questions of caste and class. So that is what we are trying to uncover here. And at some point, we will be getting to the Transgender Persons Act. But we are going to see how partly Transgender Persons Act is informed by an existing legal discourse that has happened within the understanding, the judicial understanding in NALSA, which is why it becomes very important for us to look at this site of genesis. After all, NALSA is a site of genesis, as in it is a genesis moment in a legal conceptualization of transgender persons, of third gender persons. And that is not to say that there wasn't a social conceptualization. If at all, what NALSA goes to show is for the longest time, law has been blind to the realities around it, in which much ahead of any legal conceptualization or legal recognition of transgender persons, third gender persons, there was already a social and political realization of these categories. So as we are looking to the site of genesis in which this legal conceptualization is coming to terms, and before we get to that extended legal conceptualization in the Transgender Persons Act, whether or not the Transgender Persons Act is an outcome of NALSA, but certainly NALSA is a precursor to the Transgender Persons Act, in the sense that in a chronology of time, in a sequential chronology of time, NALSA is ahead of the Transgender Persons Act. So it could be said that the discursive understanding of law on gender variance, the genesis of that understanding is located in and around 2014 when the Transgender Persons Act comes about. So now we want to see what attending to caste and class would mean for NALSA. How would NALSA understand gender variance, or say certification? How would NALSA understand that conceptualization differently if NALSA was to attend to caste and class? And that is not, it's not just a kind of a, bickering over what could have been, would have been, should have been the position within the law. Rather, it is looking to that site and learning from it, so that in any of our involvement in law reform initiatives, we are able to make improved interventions, both within social movement spaces and within litigation spaces, so that we can inform our interlocutors in such a way that there is an informed understanding of different dimensions and different ways in which we experience our identities and our social positioning. So the legal discourse on backward class is then based on a sterile and simplistic meaning of class that could be thus surmised: that caste is a class, but all classes are not caste. And subordinate castes do not experience the oppression of the caste system alike. While this would have been partly useful to another Supreme Court decision, say in Vishaka, in acknowledging the graded hierarchies within backward classes and the need for a protective legislative framework that is also based on caste, not just sex. Here, this understanding is to locate NALSA within a long-standing judicial discourse that has conflated caste and class and undermined the salience of both. Aside from insights into the long-standing judicial trends, and at the level of failed eventual outcome of NALSA, the Declaration of Transgender Persons as Socially, Educationally Backward Class, in short SEBC, this Declaration of Transgender Persons as SEBC failed to be recognized in the legislative framework to follow. So here we are starting to make interconnections between a discursive understanding of the legal conceptualization and the legal recognition of transgender persons, and how that understanding is placed within the Transgender Persons Act of 2019. So the declaration of transgender persons as SCBC is something that doesn't happen in the Transgender Persons Act. You might ask why? Why is it that that which is articulated in NALSA has somehow failed to translate into Transgender Persons Act? Is it that the two are just unconnected, right? We could say, well, NALSA was one and Transgender Persons Act is another, and there is no interconnection between the two. So it's pointless to ask the question of why this failure occurred. Why is it that the declaration of transgender persons as SEBC fails to be recognized in the legislative framework to follow in Transgender Persons Protection of Rights Act in 2019? Perhaps we are hypothesizing, perhaps because the identification of backward classes is a constitutional function of the governments at the federal and the state level, not the judiciary. So perhaps NALSA was misplaced in the assignment of backward class category on and upon transgender persons. And only because a constitutional distortion occurred in NALSA does not mean that that constitutional distortion would continue to occur even in the Transgender Persons Act. If NALSA had paid attention to Indra Sani, why? Because Indra Sani is an 11-judge bench which is ruling on the discursive judicial discourse on caste and class. So if NALSA had paid attention, why would NALSA pay attention to Indra Sani? If at all it had attended to questions of caste and class. But because NALSA did not attend to questions of caste and class, aside from a passing analogy of transgender persons are like untouchables, Supreme Court in NALSA, the Honorable Supreme Court in NALSA, arrived at certain mistaken understanding. So if NALSA had paid attention to Indra Sani, that had clarified the position, that had amply clarified the position, what we are quoting from Indra Sani now, neither the Constitution nor the law prescribes the procedure or method of identification of backward classes, nor is it possible or advisable for the court to lay down any such procedure or method. It must be left to the authority appointed to identify. It can adopt such method, procedure as it thinks convenient. This is from para 859 of the Indra Sani decision. Now, unquote. In its eagerness to declare affirmative action for transgender persons, NALSA appropriated an executive action. So what did NALSA do? NALSA, in its eagerness to declare this affirmative action, the judiciary appropriated to itself something that in a constitutional frame is left to the executive. There was no doctrinal requirement of comparing transgender persons with untouchables. Indra Sani is sufficiently instructive in the matter, and here we quote, "It is not necessary for a class to be designated as a backward class, for it to be situated similarly to the scheduled caste and scheduled tribes," unquote. Thus, NALSA demonstrates insufficient familiarity with and complete disregard of the ruling of a larger bench in Indra Sani. Now, rather than inform itself of a legal discourse that would have been binding on NALSA, the Supreme Court appears to be informed by arguments that resonate more with dominant frameworks of caste, sex, and gender. What are these dominant frameworks? The procedures of PIL are such that interventions other than initial petitioners can be brought for the consideration of the court. In this case, and in addition to the National Legal Services Authority as the first petitioner, there were a few impediment applications that included one from a Hijra activist by the name of Lakshmi Narayan Tripathi, a name that discloses the intervener's caste denomination as Brahmin, which is the highest echelon of caste-based hierarchy. NALSA does not record any personal positioning of the intervener, Tripathi, on the lines of any caste denomination or place any significance on caste, regardless of the lack of this positioning. Now, we might say that the impediment applicant Lakshmi Narayan Tripathi may not self-identify as Brahmin. So, regardless of the lack of positioning or any explicit self-identification on the part of Tripathi, caste association and identities are enmeshed and encoded within some surnames such that their reception goes beyond any self-awareness and consciousness of caste-based stature. So, for example, one of our lead discussant of the webinar, Mr. Ranit Mukherjee, who is an MPhil student at the Department of International Relations at Jadavpur University, requested our organizing team to not use his last name. And despite that, for the organizing committee to use the last name is to present that name with certain caste denomination, with certain ways in which that name will then be received with the association, caste-based association that are made with that name. Then it cannot be a matter, entirely an individual matter of self-identification, because often we are received not entirely in the ways in which we might self-identify, we are received in the ways in which the recipient of our identity is receiving us. And those receptions occur on lines of certain caste and various other lines, but one of the lines is a caste. So regardless of the lack of this positioning or any explicit self-identification on the part of Tripathi, caste association and identities are enmeshed and encoded within some surnames such that their reception goes beyond any self-awareness and consciousness of caste-based stature. Had the court been alert to this politics of naming, it would have noted a contradiction of sorts, a certain reverse mobility of caste-based hierarchies that allow a Brahmin to become untouchable. Despite the lack of any explicit labeling or signage of this Brahmin identity in Nalsa, the arguments of Tripathi intervention were aligned with the well-known Brahminical perspectives and ideas. The intervention foregrounded a more favorable historical background of the transgender persons within Hindu mythology, Vedic and Puranic literatures that are also considered historically exclusive knowledge domains of the Brahmins and the sources of pervasive caste and gender-based inequality. Tripathi's intervention made references to the repealed Criminal Tribes Act of 1871 and the inhumane manner in which they were treated at the time of British colonial rule, and this selectively foregrounds the ills of colonial oppression while remaining blind and silent about the ills of Brahminical patriarchy. This caste-blind legacy of Nalsa is advanced in a decision of the Supreme Court in Ram Singh versus Union of India in withholding the status of backwardness from caste groups such as Jats. The decision makes passing remarks obiter dicta against the identification of backwardness solely on the basis of caste. Ram Singh recognizes transgender persons as a newly emerging group that needs palliative action. Palliative as in remedial action. If you are injured, then we need a palliative action to heal that injury. Quote, moving away from, and we are quoting from Ram Singh, moving away from caste-centric definition of backwardness, this alone can enable recognition of newly emerging groups in society which would require palliative action, unquote. This means that palliative action is a zero-sum game. What is a zero-sum game? That the loss of one is the gain of another. Newly emerging groups are placed in competition with caste-centric definitions of backwardness, setting up a competition for the eligibility of backwardness. Ram Singh endorses and extols Nalsa for its recognition of third gender as socially and educationally backward class of citizens who are entitled to affirmative action of the state under the Constitution, unquote. Explicit in its attempt to dismantle the affirmative actions based on caste, Ram Singh clarifies, I quote, it is the identification of these new emerging groups that must engage the attention of the state, and the constitutional power and duty must be concentrated to discover such groups rather than to enable groups of citizens to recover lost ground in claiming preference and benefits on the basis of historical prejudice, unquote. Not only does that mischaracterize affirmative action as a scheme of preference and benefits, Ram Singh does not clarify why affirmative action must be a zero-sum game. State resources could be so increased as to provide palliative action for newly emerging groups without undermining the caste-based affirmative actions. Had there been an intersectional understanding of gender and caste in NALSA, it would have anticipated the eventual legislative outcome in the Transgender Persons Act of 2019. Firstly, what legislative frameworks on caste make it amply clear that affirmative action does not suffice. Legal protection of discriminated groups also requires prevention of hate crimes and violence. Perhaps ignorant of this comprehensive approach of legal protection, NALSA did not devise any framework of offenses and penalties. However, the Transgender Act of 2019 is explicit in its recognition of some of the violence as offenses and penalties, and Section 18 makes these offenses punishable with imprisonment of 6 months to 2 years and with fine. Secondly, caste is an immutable status that cannot be changed, while fluidity of gender categories, as conceived in NALSA, for example, self-determination of gender, would eventually fail to be recognized for the purposes of legal certification in the Transgender Persons Act of 2019. An intersectional understanding of caste and sex would have shown how the formal legal requirements of caste certification are already steeped in sex-based inequality, such that legal construction of caste is based on patriarchal lineage. What does that mean? A person's scheduled caste status is determined by the SC status of their father, not their mother. This is an apparent sex-based inequality that endures. The legal certification of caste continues to be bound by rigid and narrow legal constructs. If the certification of transgender persons was to turn out differently in any legislative outcome, then NALSA could have learned better from the legal construction of caste, and the court could have laid out a suitable transformative framework for the parliament to follow. This is going back to the question that was raised by one of our attendees, which was asking about a transformative. What would it take for NALSA to be transformative? What would it take for the Transgender Persons Act to be transformative? Then, aside from looking to the isolated sites of NALSA and the isolated sites of the Transgender Act, we've got to be able to see the prospect and potential of that transformation in various sites, at least in the site in which NALSA enters itself, which is that of affirmative action, at least within the sites in which the transgender person enters itself, which is within sites of certification. And because NALSA attempts a passing analogy of caste and gender, then it becomes very important for us, not only as a matter of identity, but also in the legal reception of that identity. What is it that the law does to the ways in which those identities are recognized? How does law facilitate the certification of those identities? What is it that the law requires? What are the parameters within which these identities are so constructed? So what is the legal construct of an identity becomes very important. This framework would have helped. What is this framework? The intersectional framework of caste, class, and gender. This framework would have helped in recalibrating the legal construction of SC categories. So this would be, a win-win for both, because had the court in NALSA done that, it wouldn't just make for a transformative legal construct of transgender persons, it would also give some material, some precedent value on and around law reform of caste-based legislations or caste-based idea. So in the absence of this framework, transgender communities and activists are left grappling with the contradictions between NALSA 2014 and the Act of 2019. And the legal construction of SC categories remains patriarchal. It is a lose-lose situation rather than the potential win-win for both transgender and SC persons. Comparisons with untouchability have more profound significance when viewed from the lens of intersectionality. They reveal a longer and more complex relationship of law and caste that is layered with multiple contradictions. Some of these contradictions can be seen in a foregrounding of caste in the Constitution of India and numerous protective special legislations that are based on caste. Despite this bulwark of legal protections, there are pervasive systemic failures of the law. And yet, there is a continuing reliance on the law as a liberatory and egalitarian tool. These multiple layers of what we know as classic dialectics are productive sites for developing a robust and critical understanding of the law and its relationship with sex and gender. These contradictions are also helpful for developing an intersectional and much broader understanding of the law, caste, gender, and sexuality. In conclusion, legal reforms in India have followed piecemeal approaches to redressing violence and discrimination on single axis frames of sex, which has meant women, and caste, which has meant scheduled caste, amidst other axes as disabilities, minorities, gender identities, and more recently, economically weaker sections of citizens. These single axis frames have resulted in a neglect of intersectionally subordinate groups as that of the SC, the ST, and the OBC women and transgender persons. The judicial text of NALSA and insights into the following legislations, the Transgender Persons Act, demonstrate this piecemeal approach. This approach is so disconnected and distant from other remedial legislation, such as the SC and the ST Act 1989. This piecemeal approach might have worked if the pieces somehow fit. But as in a jigsaw puzzle, if the pieces fit, no problem. In a jigsaw puzzle, it's a piecemeal approach and you start putting these pieces together. And in the end, you've got something comprehensive, something that is coherent. But the pieces don't fit and resulting in gaps and causes intersectional failures. A way forward could be the pursuit of more comprehensive anti-discrimination framework that are not only comprehensive for redressing multiple axes of discrimination, but also comprehensive of preventive and remedial affirmative action measures on and about the availability of transformative education and employment opportunities within all domains, public and private sector. A domain that remains relatively underexplored is personal and collective consciousness at the levels of social and political mobilizing. And that's where the set of questions posed in this presentation at the very start gain greater significance. It's a two-way street in which both the Dalit and the LGBT queer mobilizing could attend to stigma and discrimination. So the recipients of affirmative action would, and we are just listing out these questions again. We will, at this point, we'll take a break. If not for you, then for my sake, because I've been speaking for an hour and a half. And although we are accustomed to speaking at length during classroom sessions, as long as this, we do take a 5 to 10 minutes break. So it's 5 minutes past 5. We're going to take a break in which I'm going to get some water. But before I do that, I'm going to put up our slides with a set of questions. Those could be, if any of those questions are of interest to us, we could discuss those questions. But if at all we wanted to move the discussion in any other way on any other lines, that's also welcome. So with that, we are going to share our screen. We're going to take a break of 5 to 10 minutes. Let's be clear. Let's take a break of 5 minutes. It's 5 minutes past 5. We're going to resume this session at 10 minutes past 5. And before then, what we have done is reproduced the abstract, which is less of an abstract and more a set of questions. See if any of these questions, each of these questions could be various entry points into this discussion. See if any of these questions is something that interests us to follow in the discussion, or perhaps pose a separate set of questions. This would also be a good time to continue to post questions in our chat box. and our moderators could help us in collating some of these comments and questions. And when we come back after the break, it's going to be an interactive discussion. All right, so take a 5 minutes break and we'll resume at 5:10. Bye for now.
So we'll take over from here. Oh, let's all of you can refresh yourself and we'll meet after 5 minutes. Do not disconnect, please. If somebody has question, you can text in the chat box of Cisco, or you can simply raise your hand in the chat box or your participation, and we can see and simply unmute you. We have already questions from ABC. It will be great if ABC writes name and we can pose the question after 5 minutes. Right. Do not disconnect, please. All right, so can you hear me, sir?
I can. Am I still audible and visible?
Yes, sir, absolutely perfect. And
Okay.
we have some question. If it is fine, you to address this question, and you may address this question after your continue talk. So, however you feel.
No, so this is now interactive in the sense that at this point we are only and entirely relying on a set of comments and questions to steer this discussion. Because
Yes.
by now, what we've had is a set of questions and a wide, quite extensive engagement with the judicial text of NALSA and the loss potential of NALSA. What is the value, salience, significance of this intersection of caste, class, gender, and sex categories? And within that, more specifically, if there is any overlap between, say, the formulation of affirmative action in the NALSA decision, then in what ways does that formulation of affirmative action overlap with existing formulations of affirmative action within categories as the SC, the ST, the backward classes, and those then would be the launch pad or the platform from which we could take more abstract leaps into, say, the set of questions that we have posed for this session. I am trying to access the chat box so that I can look at some of these. And I think the thing about sharing screen is that at my end, I lose the window which would allow me to view the comments. So until now, I've not been able to. It would have helped during the break, for example. I could have quickly looked at these comments, but I'm not able to do that because we are sharing screen. I just wanted to know if the set of questions is not something that we want to keep for ready reference at all times, then we could stop sharing screen, and that would allow me to look at the comments for myself. But if that is something that the moderators can help us with, then we can work with that option as well.
We have collected some questions from the chat box, and we can directly pose it to you.
Let's do that. Okay.
All right, sir. So there are a few questions from ABC. I don't know about the name. In our Indian constitutional, there is any reservation for transgender persons? This is from ABC. And the next question of the same person is that how many amendments are cleared for caste, class, and sex for transgender persons?
Say that again.
Uh, how many amendments are cleared for caste, class, and sex for transgender persons?
Amendments in the Constitution, or
Yeah.
I'm not understanding amendments where?
It's from ABC. Like it has
Okay,
to be in
so
constitution.
the part of the question is there any provision for reservations for transgender persons within Constitution?
Yeah.
And the other part of the question is, are there any amendments? So presuming
Yeah.
amendments within the Constitution then, for and on and about transgender persons?
Yeah.
Okay.
And there is one more question of the same person. If it is okay, I can pose.
Yes, please.
Which is the large bench for transgender persons based on economy?
Would it be better for those of us who are posing these questions in chat boxes to pose these questions themselves? Because that would allow us to gain some clarification as to the content of the question, unless we are
Actually,
so constrained by
ABC isn't
technology.
that, so he can only. I mean, ABC can only text. Otherwise, I'll
ABC can
unmute anyone.
Okay, okay, all right. So those of us who are open to unmuting themselves, it would be good to hear from those of our attendees directly. But if, of course, for any reason we are unable to unmute ourselves and speak, then of course we would have the aid and assistance of our moderators. What's the second question that ABC has raised?
Amendments in constitution for transgender persons.
Okay,
And
got
which
it.
is the large bench for transgender persons based on economy?
Say that again.
Which is the large bench for transgender persons based on economy? I don't know about the context of this question.
Yeah, so if you're struggling to understand, then I would say that I'm somehow similarly struggling to understand. When we say bench, we say the size of the bench, as in whether it's a constitutional bench. Even within constitutional bench, there are various varying number of judges. So is it that bench that we want to know?
I
So for
hope so.
example, do we want to know what is the bench in NALSA?
Yeah.
Okay, go on. Let's list out these questions and then we'll get to these more selectively.
Yeah. There is one more person, Chinmoy De. I guess Chinmoy De can speak. I'll mute Chinmoy De. Please, Chinmoy De, you can pose your question directly. Chinmoy De, are you there? I okay. Let it be. Pura, there is some Puravism. Yeah, I can. Puravism can pose and ask directly. I have unmuted you. Please go on. Certainly, there are some technical issue at their end, so I can directly ask their question on their behalf. So, Pravism asks, is transformation of transgender possible mentally where they are categorized as a separate category others, as we very much know that our patriarchal society is the owner of legal control and always support class caste discrimination?
It would help me to look at these text of these questions myself. So I'm going to stop sharing the screen so that I can. Okay, tell me the name of the person that you're reading from. Good. Pura Bisnem, is transformation of transgender possible mentally where they are categorized as a separate category? Others, as we very much know that our patriarchal society is the owner of legal control and always support class caste discrimination. You know,
Can I ask?
yes.
Yeah, I just had a question. I wanted to know how do caste and class combinations sort of operate among Hijra groups that are, differentially distributed in different parts of our country. How do these combinations really sort of operationalize in the kinship structures in these Hijra groups? And what kind of challenges do these people really face in that community? And how do we, sort of imagine the futures of queer politics alongside caste and class politics that sort of would help us problematize and sort of also make the queer category more inclusive and porous so that people from different caste and class backgrounds feel comfortable and included in this particular category.
Yeah. Um, in what way does caste and class play out within Hijra groups? Would be a question of ethnography, and we would be looking to the works of sociologists and anthropologists, and I would be going out on a leg because I'm neither of the two. in the sense that I would rely on the literature and scholarship, such as books like Neither Man Nor Woman, Hijras of India, or I would rely on certain anecdotes that appear in the print media, in the news media. So recently, with the news of akhadas, akhadas in the sense that it's an intensely religious site within which it became possible for Hijra akhadas. And as much as that event lent certain visibility both to the Hijra persons as well as to the cause, there were certain reports that revealed insights into the internal structures that are caste and class based. And it becomes important for us to pay attention to these revelations because, aside from these revelations, the commonplace understanding or a kind of a self narrative that could be advanced in public places by or on behalf of Hijra groups could be that there is neither caste nor religion amidst us because we are beyond both. And there is a certain egalitarian structure, etc. While we know from sociological accounts that there are gradations and hierarchies within gharanas, within Hijra gharanas, and these hierarchies are on the lines of caste and class, or it might be on the lines of individual personalities as well. In the context of gharanas, we know that there were newspaper reports or there were news reports about the sequence to who can bathe on the riverside, ghat, who can bathe on the ghat, ghat translated in English as riverside, at what time. And in that sequential arrangement, we know that there was a priority of the Brahmin, and the Dalit Hijra was disallowed from bathing on the riverside in the morning because they're given the prescribed time slots for non-Brahmin or Dalit Hijra was in the evening. Now, that event then becomes a matter of news report, and it becomes something that reveals the hierarchies or the structures that the Hijra community would comply with, especially while gaining admission into a space as that of the Akhada. So, admittedly, what happens is that visibility and that admission, that space of reform, that reformative potential is within and at a certain cost. And that cost is compliance with a Hindu order that would be invested in a caste based prescription. So, to ask the question about internal hierarchies, internal gradations, is an important question because it reveals to us in what way is the community, in what way are the groups composed and constituted, especially on the lines on which the groups are going to seek law reform. And if those lines are going to be egalitarian law reform, then there is going to be a reverse scrutiny of the groups themselves, and it would become a point of commentary, negative commentary, when certain gradations and hierarchies are revealed within a group that is seeking reform on more egalitarian lines. So, those are some of the consequences that academics, scholars, practitioners like myself would look into, because partly to understand internal hierarchies for the sake of understanding internal hierarchies could be, what do we say? how do we say it? What is the word in which we say we are only just looking inside for the sake of looking inside? There is a word for it, and it's slipping my attention. Voyeuristic. So it could be a voyeuristic insight into the ways in which groups are composed. We're not interested in gauging the or knowing the composition of the group. We want to know the composition of the groups because the composition of the groups then has consequences for who has what kind of representational ability. And if the composition of the group is going to confine the representational ability of those who are conventionally disadvantaged, of those who are subordinate in a multiple axes of subordination, then that becomes a matter of reform within the group, especially if that group is going to seek a reform on certain lines and principles outside. So now I've stopped looking at that chat box. So perhaps we could prioritize those of us who are able to unmute themselves, because that makes for a greater comprehension as to what is the question, what is it that we are getting to. That makes for a discussion. Sometimes reading these questions in the chat boxes is not allowing us sufficient understanding of what is the question that is being posed. Anything else? Anybody else? Anup Sharma has a question. I'm just randomly reading from the chat box.
Yeah, you just answered my question. In fact, I asked the question to you, and you sort of were also maybe saying that even within the Hijra commune or collective, there is an internal hierarchy that is disturbing, whether it's along the lines of religion, caste, class, or even kind of a power structure where one can occupy a superior power space over somebody else. And that sort of a contestation is something that is very, very possible, and is possible in different situations and circumstances, and dependent upon where the subject is and how he perceives his subject position as against that object that he sort of creates. But then, do you think that legalizing the space of a Hijra community, which also sort of builds itself on the ground of some kind of a hierarchy, and of course outside that community in the social space also we have another hierarchy, which is definitely what the Hijra space is imitating. So the Hijra space is also exclusionary, and at the same time the society at large also of course obviously is exclusionary. But then that exclusion, that exclusive space is also sort of protecting the Hijras from some sort of course, from not some sort, but the patriarchal violence that it publicly is subject to. So what I see is that a kind of discrimination is sort of creating an exclusion, and that sort of becomes a space of protection and rehabilitation. But again, in the internal space of the Hijra community, also there is a code of hierarchy that is also based on exclusion and some sort of discrimination.
Sure.
So I'm not able to understand how all of these exclusions can sort of, also be a part of the polity that we sort of imagine, as queer people, and what we see manifest or we want to see manifest in the queer prides or whatever queer collectives we form and make, wherein we desperately try to sort of make it more inclusive for everybody, but again fail to do so. So my question is basically on the legal front, what kind of legal challenges does a queer form of imagining politics across the lines of class and caste and religion and all of these discriminations have, with respect to taking up the Hijra community also in its fold? Because the Hijra community itself is in many ways very much excluded from the kind of queer movements that we see, and at the same time also is also projects itself as some as an exclusive space, so how can we sort of channelize them into the larger mainstream or whatever queer movement that we have, and at the same time also keep into consideration that there are certain very specific and individual cultural, historical modes and methods of identifying and belonging, that they have sort of sustained over the years. So how do we really navigate this complex you know movement between Hijra communities, you know, with respect to the larger mainstream queer project, and at the same time, with respect to their own individual space of belonging.
Excellent, and an excellent set of questions. And I wouldn't be able to, even attempt to address all of these questions, but I would be a little more selective as to the questions which resonate more with some of that I know relatively more of. So I think one of the questions is that of legal recognition or legal conceptualization of the of any structure or any relationship that might already be steeped in some kind of an internal gradation and inequality, and how are we going to resolve that? And I think one site that we could look to that would be an illustration, not as an aspirational model, but certainly an illustration of internal gradations and hierarchies that are only well recognized within the law and are actually promoted and advanced in, say, the legal structure of marriage. Because we know that heterosexual marriage and a legal construct and a legal conceptualization of marriage and family laws are already steeped in a sexist kind of understanding that would not just create, but secure the inequality of sexes. So, certainly, internal inequality and gradations is not going to disable the law from attempting to conceptualize a project. And that internal equality is not something that and that internal equality is often projected as a site of privacy. For example, in principle, one of the contradictions to what could be argued as privacy is the legal understanding of domestic violence, because in a legal understanding of public and private, we know that the law enters selectively into the private realm, and partly the project of the law is concerned with the public and the public spaces, and would turn a blind eye to what is happening in private spaces, right? And the other part is the reformist part, in which the law might intervene in private spaces precisely to attempt a reform which is to address a domestic violence. So there are several ways and means with which internal hierarchies and gradations are addressed within the law, and there is no one homogeneous characterization of that. As activists, as scholars, as academics, as practicing lawyers, I think the best that we can do is to inform ourselves of the range of characterizations that is available to us, and then to decide what kind of a characterization do we aspire for. Because it is the aspiration with which we move the magical wand of law reform that it would, in the least, even attempt to fulfill that aspiration. But if at all our aspiration is so curtailed and it is on single axis frame, that we work only, say, on sex issues and on gender issues and on caste issues in silos, then even that aspiration is limited. And this is getting to another segment of your question, which is that of how do we and what do we do with our understanding of intersectionality, that of caste, sex, gender, and various other intersections that or what is the legal challenge? Then I think the biggest challenge is that of invisibility and erasure, because many of these issues have not even begun to be articulated within more conventional spaces of the law, within more conventional, even academic articulations. So then, what we need to do in one part is to do our social mobilizing, is to attempt to address some of these at a collective level. But before we attempt to address anything at a collective level, we've got to be able to address it at a personal level. So sometimes issues of intersectionality can be intensely, they can evoke intense anxiety. And that anxiety can be evoked at a personal level, at an individual level. It can be invoked at a collective level, in which intersectionality can result in very bitter fights about who's representing whom, and then it's almost impossible to resolve, right? So if intersectionality is going to evoke such intense anxiety at an individual level, at a collective level, then what are the chances that we as a collective would be able to provide any coherent articulation of what is it that we demand on intersectional lines? And if we are not able to generate that coherence of an intersectional demand, then it is very likely that the projection of the law or the understanding of the law would remain blind. They would continue to be a silence and erasure and invisibility. Partly the project of the law, advertently or inadvertently, creates divisions, and what we were discussing in Ramsing, for example, the zero sum game. To say it in another way, if the law is going to, reward selectively, that, well, there are these resources available and I'm going to give it to you, but I'm not going to give it to you. What is that going to create? It's going to result in a resentment. It's going to result in a resentment that is not conducive for an intersectional understanding, because rather than solidarity, rather than collaboration, what that kind of a projection of the law would do would be to create more and more divisions and subdivisions. So there are multiple ways of understanding intersectionality, and I think that we all would be a little less on the edge, and both at a personal level, at a collective level, at the legal level, if we view that there are larger forces that are securing the isolated ways in which communities are mobilized. There are larger structural hindrances to the project of intersectionality. And with that kind of an understanding, perhaps we can begin to navigate these areas in a more informed manner and less in an agitated and anxious manner. It's important for us to understand some of that agitation and that anxiety, and to know that it isn't only a factor of, or it isn't only a characteristic of ourselves as people or our communities. Rather, there might be the dominant characterization of the law that might be acting upon the very subjectivities of these social movements, that these social movements are somehow unable to work along intersectional lines. So I think broadly, of the wider set of questions that were just posed, we might have selectively only just addressed a couple of them, but then these questions are profound. And I think for an exploratory discussion, some of this might be helpful too for us to continue thinking. Is there anything else? Anybody else? Do we want to bring this session to closure? Because I know that our organizing team wants to discuss some of the previous sessions, and to maybe just to discuss some of the main points from there. So if there aren't any comments and questions on the this session, Affirmative Action Pride and the Intersections of Caste, Gender, Sex, then perhaps we could hand it over to the moderators for
Thank
them to
you.
transition to the next level.
Thank you, sir. Actually, we have come to an end of this session. It is wonderful to have a talk with you, and we heartfully thank you for delivering this wonderful lecture. And uh, the meeting is going to be end. And please fill the feedback form. And we again thank Sumit Baudh, sir. All right, sir. Thank you so
All right.
much.
Thank you so much for having me, and all the very best. Keep doing the great work that you're doing. Keep it up, and keep me posted of your progress, of your advancement, of your accomplishment. I wish you all the very best from the bottom of my heart, and look forward to connecting with you all again. Bye for now.
Certainly, sir. Bye bye, sir. Have a good day.